I'm Ben Meiselas from the MeidasTouch Network. Another pretty unusual order for Judge Aileen Cannon in the Southern District of Florida federal criminal case against Donald Trump, being prosecuted by special counsel Jack Smith. We previously reported on the fact that Judge Aileen Cannon granted special counsel Jack Smith's request for a protective order as it relates to Donald Trump and the CIPA aspect of this case, the Classified Information Protections Act protective order under Section 3, and by and large rejected everything that Donald Trump was requesting, including the fact that Donald Trump wanted a SCIF, a sensitive compartmented information facility, to be built at Mar-A-Lago so he can review the classified documents at the crime scene where he stole the classified documents. Well, shortly thereafter, Judge Aileen Cannon issued another order, this time as it relates to Donald Trump's co-defendant, Waltine Nauta. Nauta is Donald Trump's assistant/valet, worked with Donald Trump when he disgraced our country in the White House as well. Waltine Nauta is in both the indictment and the superseding indictment for his effort in obstructing justice, making false statements. He was not charged with willful retention of national defense information, the same way Donald Trump was charged with willful retention of national defense information. So one of the things Waltine Nauta and his lawyer, Stan Woodward, petitioned Judge Aileen Cannon to do, which, as I said here, would have been patently unlawful, would have resulted in Judge Cannon being reversed, is Waltine Nauta requested access to our government's classified records that were at issue in the underlying criminal case. And special counsel Jack Smith argued, no, Waltine Nauta shouldn't have any access to any of the classified top secret defense information because Nauta is not even being charged with willful retention of the national defense information. So why would he and his defense counsel need access to those documents in the SCIF? Just because, and Nauta was like, well, I used to be in the military, so I used to have a security clearance, so therefore I should look at him. Well, used to is not you do have one, and that's not what CIPA, Classified Information Protection, that's the P in CIPA, Classified Information Protection Act, is all about. So Waltine Nauta requested access to the classified documents that Donald Trump stole. Jack Smith opposed it, and yet again, Judge Aileen Cannon rejected the defendants, as she previously rejected Trump's request. She rejected Waltine Nauta's request here and sided with special counsel Jack Smith. To give you the key point of Judge Cannon's, again, odd ruling. At the end of this video, I'm going to talk about, though, why I don't want to give Judge Cannon too much credit, or frankly any credit at all. I think she's doing the bare minimum, so she's not removed from the case right away. I think she's smart enough to realize that Jack Smith, by filing these documents and educating her on CIPA, laid the perfect legal trap. She understood what was going on, so she made the appropriate rulings here. But it is the appropriate ruling. So this is not one of the times where I say Judge Cannon made a, horrific ruling. She didn't. She made a pretty normal ruling here. Now, also took her a long time to make this ruling. I mean, this case was brought originally, the original indictment, back in June, and the Classified Information Protections Act protective order is first getting entered September. But by the way, not a bad deal when you think about it, because what's happened since then? Well, Judge Tanya Chutkin in Washington, D.C. swooped in, and she's the judge presiding over the federal criminal case against Donald Trump for his attempt to overthrow our free and fair election in 2020. And she set the trial date for March 4th of 2024. So that case now has the priority of dates over this case. So here's the key section of Judge Cannon's unusual order, but a good order. Paragraph 8, it says, the defense, Waltine Nauta's lawyer, the defense may not disclose classified information to defendant except as set forth in paragraph 26J or as permitted by any supplemental order. Any classified information the defense discusses with the defendant Waltine Nauta in any way shall be handled in accordance with this order, including such requirements as confining all discussions, documents, and materials to an accredited SCIF, sensitive compartmented information facility, or other location authorized by a CISO, a classified information security officer. Okay, so then we have to scroll down, go to 26J. So what is the full sum of documents that Waltine Nauta can look at under this order? We look at 26E, 26F, 26H, 26J. There it is right there. It says, the government agrees to disclose to defendant Waltine Nauta as classified information only, quote, the unredacted version of the picture included in paragraph 32 of the superseding indictment and the document charged in count 8. Any future disclosure of classified information to defendant shall be governed by subsequent order. Okay, so it is limited to that paragraph. And so let's take a look at what that paragraph says.
This show is sponsored by BetterHelp. Do you ever find that just as you're trying to fall asleep, your brain suddenly won't stop talking? Do your thoughts start racing right before bed or at other inopportune moments? Now, I know my job can be very demanding, and I know my mind is always racing, whether it's work-related or family-related. I personally benefited from therapy because it allows me to discuss my feelings of uneasiness or stress factors and find ways to cope in a healthy and productive way. It's helpful for learning positive coping skills and how to set boundaries. Therapy also empowers you to become the best version of yourself. It isn't just for those who've experienced major trauma. Now, whether you're dealing with decisions around your career, relationships, or anything else, therapy helps you stay connected to what you really want while you navigate your life so you can move forward with confidence and excitement. Now, if you're thinking of starting therapy, give BetterHelp a try. It's entirely online, designed to be convenient, flexible, and suited to your schedule. Just fill out a brief questionnaire to get matched with a licensed therapist and switch therapists at any time for no additional charge. Get a break from your thoughts with BetterHelp. Visit BetterHelp.com/Meidas today to get 10% off your first month. That's BetterHelp, HELP.com/Meidas.
Pull it up right here. Paragraph 32. On December 7th, 2021, Waltine Nauta found several of Trump's boxes fallen and their contents spilled onto the floor of the storage room, including a document marked secret/REL to USAFVEY, which denoted that the information in the document was releasable only to Five Eyes, that's FVEY, Five Eyes Intelligence Alliance, consisting of Australia, Canada, New Zealand, the United Kingdom, and the United States. Nauta texted Trump employee 2, quote, I opened the door and found this. Nauta also attached 2 photographs he took of the spill. Trump employee 2 replied, oh no, and I'm sorry, POTUS had my phone. One of the photographs Nauta texted to Trump employee 2 is depicted below with visible classified information redacted. Trump's unlawful retention of this document is charged in count 8 of the superseding indictment, and it's redacted because it's spilled on the floor, and in the photograph that Nauta took, you can see the actual photograph, but Nauta no longer has access to that photograph. So here, the only thing Judge Cannon's going to let Nauta look at, absent additional orders or additional guidance by the CISO, Classified Information Security Officer, is the document in an unredacted form in the photograph that Waltine Nauta took. So a big loss for what Waltine Nauta and Waltine Nauta's lawyers were trying to accomplish here when they wanted access to all of the classified information. In other words, it's a big win for Special Counsel Jack Smith. Looking at this order again by Judge Cannon, granting the Department of Justice's protective order. Here you see protective order pertaining to classified information disclosed to Waltine Nauta and defense counsel. It talks about how this matter comes before the court upon the government's renewed motion for protective order pursuant to Section 3 of SEPA. the Classified Information Procedures Act to prevent the unauthorized use, disclosure, or dissemination of classified national security information and documents that will be reviewed by or made available to or otherwise in possession of defendants and defense counsel in this case. A sealed hearing was held on the motion on September 12, 2023. You may remember Special Counsel Jack Smith had to school Judge Aileen Cannon. Hey, Judge Cannon, you know these SIPA hearings, Classified Information Procedure Act hearings? You know, they need to be held under seal. You scheduled one for late August in front of the public. That's a mistake that you made. So then she held it under seal. And then she says, pursuant to the authority granted under Section 3 of SIPA and the security procedures and the protection of classified information, it is hereby, the government's motion is hereby granted in accordance with this order. And as discussed during the hearing, the following protective order enters. And it talks about how the documents at issue in this case involve classified documents in the interest of national security that are the possession not of Donald Trump, not of Walter Nauta, of the United States government. So recall, Donald Trump is being charged with willful retention of national defense information that doesn't belong to him. And this order reaffirms a very basic concept that this doesn't belong to him. He shouldn't have had it. It doesn't say that directly, but it says clearly this is the possession of the United States government. Finally, I'll leave you with this thought, though, why I don't think we should be clapping for Judge Cannon for doing the bare minimum. She entered the correct order here. If she ruled the opposite way, she would have been removed from the case. Jack Smith was ready to go to the 11th Circuit Court of Appeal and was ready to call her out and likely ask for her recusal if she made such egregious reversible error here, because remember, the 11th Circuit has previously admonished her twice in 2 orders reversing her and saying that she made egregious mistakes, egregious reversible error, asserting jurisdiction back in 2022. So she did the bare minimum here to not be taken off the case. So she will remain on the case, and I think she can still do mischief at trial. But I think what this shows is that she feels constrained. She recognizes that Jack Smith knows the law far greater than she does. I think she realizes that the 11th Circuit is ready to reverse her. So I think that she's not going to do anything to totally derail it yet. But then there are things that, like jury selection and pretrial motions and motion to dismiss, where I think we have to be very weary of what she's going to do, which she's trying to get to that stage, and she's smart enough to not make the egregious error here so as to get to that stage. Well, we'll follow up. We'll see what happens. We'll keep reporting here on the MeidasTouch Network. But again, for now, that order was the correct order by Judge Cannon. And I guess that is different and unusual than her past. Check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch, wherever you get audio podcasts. Subscribe to the MeidasTouch podcast. Hit subscribe here on YouTube. It's free. Have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.